And a warm welcome to the 15th meeting of the Constitution Europe External Affairs and Culture Committee in 2025. Our first agenda item this morning is a decision to take item 3 in private. Are we agreed? Thank you. Our next agenda item is to take evidence from the Scottish Government Bill team on the UEFA European Championships Scotland Bill. And we're joined by Rachel McKechnie, Deputy Director of Major Events, Lucy Carmichael, Head of Euro 2028 Unit, and Ninian Christie, Legal Director at Scottish Government. I welcome you all, and can I start by inviting Ms McKechnie to make a short opening statement before moving to questions from members.
Thank you, Convener, and thank you to the committee for the opportunity to give evidence about the UEFA European Championship Bill. In this statement, I would like to cover what the bill does and why Euro 2028 is a great opportunity for Scotland. The aim of the bill is to support the successful hosting of Euro 2028 by meeting specific requirements set by UEFA as the rights holder to put in place commercial rights protection measures. The bill does this by prohibiting the unauthorised sale of championship tickets above face value or for profit. This applies to all matches. It also prohibits unauthorised street trading and advertising within designated event zones. The bill establishes criminal offences for ticket touting, unauthorised trading and advertising, and creates an offence of obstructing an enforcement officer. It includes measures to enable these offences to be enforced. The bill requires Glasgow City Council to publish guidance on trading and advertising measures and offer alternative arrangements for street traders affected by the restrictions. For Euro 2020, a bill was brought forward that followed an expedited process. Feedback from that bill process included that the need for legislation should have been identified sooner. The Scottish Government has taken that feedback on board in bringing forward this legislation. This will provide certainty to businesses and others farther in advance. Earlier development of the legislation has also meant there has been more time for consultation than was possible for Euro 2020. A public consultation on the bill took place in 2024. The independent analysis of the response demonstrated general support for the proposed measure to safeguard commercial rights for Euro 2028. The prevailing theme was that there would be no significant impact on respondents. During this period, the Scottish Government officials engaged through various routes, including liaising with key stakeholders, attending a Mount Florida Community Council meeting, and holding in-person and virtual sessions to provide an overview of the bill and gather feedback. This engagement has informed development of impact assessments, including mitigations for the limited impacts identified. More generally, Euro 2028 is a significant opportunity for Scotland to generate economic and social benefits. This will be the biggest sporting event ever jointly hosted across the UK and Ireland, delivered in partnership with UEFA, the football associations and other government partners. We want it to leave a positive legacy for local communities. We aim to make football more inclusive and more accessible, delivering a welcoming, exciting and safe festival which players and fans will enjoy in every city and at every game. Euro 2028 will showcase Scotland internationally, promoting our nation as an ideal place to visit, study, work and invest. The tournament is predicted to generate socio-economic benefits of up to £2.6 billion across the UK and Ireland. It will provide opportunities for a number of sectors, including tourism and hospitality. Hosting offers another opportunity for Glasgow to demonstrate its welcoming, diverse and energetic character to a global audience. And a key Scottish Government objective is spreading the benefits more widely across Scotland. Overall, Euro 2028 will be a fantastic tournament. The bill that we are discussing today is key to ensuring that Scotland can be part of it. Convener, I'd like to draw my remarks to a close here. Myself and colleagues now look forward to the discussion with members.
Thank you very much, and thank you for filling in a bit of the history with the 2024 bill as well, which is very helpful. I wonder if there had been any consideration given to including some delegated powers in the bill to allow the Scottish Government to implement, virtually the same conditions on a championship coming forward again in the future.
Sorry, Convener. So when we looked at options through and looked at the business and regulatory impact assessment, there were three options that we considered. So we considered the do-nothing option, we considered a standalone bill, and we considered it essentially a framework legislation that would allow us to essentially craft conditions for future events that came through. On this occasion, we felt that the standalone bill was the best approach for Euro 2028. UEFA are very clear on their timings for the ticket touting restrictions in particular to come into effect for summer 2026. With the election coming up in May 2026, we were obviously considering timescales. Through the consultation, there was not any kind of very clear policy aims that were coming through stakeholders in terms of a framework legislation within there. So we felt on this occasion, particularly given for Euro 2020, because it was an event that was delivered through COVID, we were therefore unable to get significant amounts of impact data from there as well, that on this occasion there were probably a number of reasons that were driving us to a single issue bill. Lisa, do you want to add anything?
Not a huge amount, Rachel. I mean, as Rachel says, we did have a question on the wider regulatory framework in the public consultation that we undertook. In terms of responses to that, there wasn't a clear ask for framework legislation, as Rachel's picked up. There were some suggestions to review particular legislation, so things like the 28-day planning rule for temporary structures, operation of the Civic Government Scotland Act in terms of licensing of short-term lets, and reviewing the Civic Government Scotland Act in terms of licensing arrangements. So I think that's a much broader kind of set of measures in the regulatory environment that we are covering in this bill specifically for Euro 2028. So as Rachel picks up, I think it would require more policy consideration and development than we have time for in this particular occasion because, as we say, the timescale is driven by UEFA.
Okay. Thank you. That's helpful. I'm going to open to questions from members. Mr. Kerr.
Do you want to go first?
Mr. Kerr? Yeah,
right.
That's fine.
Good morning. Obviously, it's very exciting to have a major global sporting event happen right on our doorstep. So we'll all be very supportive of that. There are a number of aspects of the bill, though, that I think deserve proper scrutiny. Can you possibly explain the ticket touting elements of this bill? Because does this prohibit ticket touting, as I understand it, only in Scotland? I'm thinking of Schedule 1, which seems to suggest that the provisions of Section 2 about ticket touting only seem to apply to the territory of Scotland, and it's quite possible for tickets to be sold, touted, outside of Scotland, and this element, the Schedule 1, the ISS provision, that can be done online. How are we going to police any of that, or is that outside of the reach of our considerations?
Yeah, I'm happy to pick that up. And Ninian, I might come to you just for any further comments at the end around the ISS schedule. So you're absolutely correct that there's been a change for the ticket touting measures in this bill compared to the Euro 2020 legislation. So the ticket touting offence now does apply only within Scotland, and it does apply to all matches in the tournament. The reason that we made that change is we undertook further engagement with Police Scotland and with the UK Government around about the threshold for extraterritoriality, and I think it became clear as part of that engagement that such a broad application of extraterritoriality didn't meet the threshold for the offences in this legislation. So we obviously are working with other governments, the other nations that are hosting, around about any measures that they will have in place around about ticket touting, but we think the proportionate way that we can the proportionate way to have enforcement in place is in Scotland, and that is something that Police Scotland can take forward. Now, clearly there is an online element of ticket touting. I think that has increased, particularly since the original legislation around rights protection for Commonwealth Games came forward in 2007. So, but that is something that Police Scotland can consider as part of their operational enforcement. We have been discussing that with them in terms of online aspects, and I think we could ask Police Scotland if they're able to provide any further details around about considerations of that, if that would be helpful to the committee.
Yeah, I think it would be useful to have as much information about that as possible. So is it possible that the UK Government, the Welsh Government, that there's going to be similar legislation but will that prevent someone from touting a ticket in Carlisle, just the other side of the border, for the games that occur in Glasgow?
So we're working very closely. We have a good, strong, constructive relationship with all the other host governments, and we're working with them on legislation as part of the wider tournament delivery arrangements and discussions that we're having. It will be for other governments to explain any changes to legislation or any additional measures that they'll be bringing forward. As Rachel's already mentioned, because we've got the Scottish Parliament election coming up, there has been a particular time driver for us in bringing forward this legislation now.
And continuing on the same subject, the section 2(4), why are UEFA or the officials of UEFA exempt from the touting offence? Now, I understand about secondary markets, and UEFA might want to set one of those up officially, and I get all that. But touting? Why on earth would someone who works with or for UEFA be able to stand outside Hampden and tout a ticket, but the guy that lives along the road in Mount Florida, he can't do that? I don't understand that.
So that's absolutely not the intention of that exemption. And again, I might come to Ninian when I finish speaking, just to see if you've got anything to add. So starting with what the ticket touting offence captures. So it captures sales above face value and sales for a profit. Now, when UEFA is making initial sales of championship tickets, it obviously does that at face value, but UEFA does generate a profit from those sales. Now, by far the majority of UEFA's revenues are reinvested back into football, but they do make a profit. So that's why they need an exemption from ticket touting offence, but that's not intended to allow individuals who work for UEFA to tout tickets. It's very much for UEFA as the corporate entity to be able to sell tickets through its website, and also to ensure that its resale platform, which will allow fans to exchange tickets at face value, that's not caught by the offence, because otherwise there wouldn't be any way for tickets to the championship to be sold legally, I suppose, in Scotland. Ninian, would you want to add anything to that?
Yes, as you've said, Section 2(4)(b) is not intended to allow people on their own to be outside Hampden selling tickets. It's third party platforms or something that might be engaged by UEFA to actually carry out the resale on their behalf, rather than directly UEFA. For all sorts of reasons, they may not choose to carry out ticket sales directly, but they would. So the intention isn't to authorise just one person or individuals to have a letter to allow them to resell tickets.
I completely understand the secondary aspect of this, because that's part of the fixture, isn't it? Now, concerts, games. I just think it looks very odd, frankly, that we've got this whole thing about touting, and then in the middle of it says UEFA can effectively bypass all that. I think I understand what the intention is, but I would question where it sits in the bill in connection with touting. But that would just be my take on that. There are similar issues in relation to the selling of tickets in Section 3. I understand about the charities. However, there are many really good causes that would benefit from a charity auction of a ticket that are not necessarily registered charities. For example, a local hospital or a school. Was there any consideration of that aspect of the charitable dimension of Section 3?
So, and again, Ninian might want to add in terms of ECHR considerations at the end of my answer. So the charity auction exemption, so that was a point of feedback from the lead committee for the Euro 2020 legislation as part of stage 1 evidence. So the Scottish Government took that feedback on board and created the charity auction exemption for Euro 2020, and then we've replicated the provision for that in this particular legislation. I think we did consider where it's appropriate to draw the boundaries around about that exemption, and again I think while we want people who auction tickets for charities who are trying to do a good thing, we don't want to criminalise them, we don't think that that's proportionate. The exemption is not about encouraging or incentivising charity auctions, because those would still breach UEFA's ticketing terms and conditions, and there is still a risk that then those tickets would not be valid for entry. So I make that point, and we want to work with UEFA to raise awareness of that as part of our kind of communications around about the offences. I suppose the point that you're making, I'll come back to how we kind of drew where the line was. I think there needs to be some way to make sure that the charity auction exemption isn't exploited, and therefore I think we need some sort of a measure or a test that enforcement officers can look at. And I think looking at whether a charity is registered in a register that's either Oscars register or analogous register, or has kind of core functions along those lines, I think that does seek to make sure that while there is a well-defined exemption, it can't be exploited.
But it can be, can't it? Because 3.2b permits a body out with Scotland, England, Wales, Northern Ireland, the Republic of Ireland to do what I'm suggesting for the local hospital or the playgroup, or something that's not necessarily a registered charity. I mean, you could set up, organise it. And by the way, that would include the Isle of Man, Jersey, the Channel Islands.
Yeah.
So it seems to me that we're being particularly harsh here in relation to organisations that are not registered with Oscar.
What I think we're trying to do here is strike a balance and recognise that for overseas, for other countries, there might not necessarily be a register that's analogous to the Oscar register, and therefore if it can be demonstrated that the body's purposes consist only of one or more of the charitable purposes mentioned in the Charities and Trustees Investment Act, then it could apply to those charities, I suppose, or those bodies that have similar functions to charities. I suppose in considering where we draw the boundaries, we did consider whether we would limit the exemption to charities only based either in Scotland or in the host nations. There was an ECHR consideration around about that, so where we landed in terms of that consideration around about discrimination, and I probably do want Ninian to add a little bit at the end of this, is that either we needed the exemption to apply to charities worldwide, or kind of bodies that could demonstrate similar charitable purposes worldwide, or we didn't have a charitable exemption. So I think on that basis we landed on the drafting of worldwide, which included taking into account countries that wouldn't necessarily have an equivalent register to the one that we have in Scotland. Ninian, around about the ECHR considerations, anything to add?
Yes, so the test that's set out in section 3.4 is allows us not to discriminate in cases where there are places where there isn't a sort of corresponding register to Oscar. So yes, so if yes, so that's the point of that. So we can apply that. So that test can be applied where so in maybe because many other nations there is something that corresponds to Oscar or broadly, but in some countries they just don't have a similar structure of registered charity registration. So, but if we said only registered charities, then we'd be there'd there'd be a breach of or might be a breach of Article 14 Article 14 ECHR might be engaged in that we're discriminating on the basis of against charities, albeit they're not registered charities as we understand them, but they are essentially charities, but on the basis of their national origin, because they can't register in their where they're based.
Okay, I mean, there's obviously quite a lot of stuff to unpack just in that bit of the bill. And the other bit, if I might mention, the other bit obviously that concerns me, I mean, don't get me wrong, I'm very delighted that we've got this coming to Scotland, to the UK, but there are bits of it that kind of stick in the throat, and UEFA are a profit-making organisation. We're effectively clearing a part of our country out so that they can have an unrestricted ability to make profits for themselves, and part of that is the outdoor trading, basically the removal of all of the normal Scottish outdoor trading organisations, the burger vans and everything from that whole area. That does somewhat stick in the throat a little, because basically the bill doesn't seem to suggest, well, doesn't suggest to me that these businesses will in any way be compensated. I mean, these big match days are probably the big revenue days, you know, the Black Friday of their business. Every time there's a big game at Ibrox or Parkhead or wherever, and Hampden. There's nothing in the bill about, it says that they will be basically moved to another place. I mean, they're not going to be anywhere near the crowds that they want to sell their products to, so they're not going to make the same money. So, but there's nothing in the bill about compensating them in any way.
And then Rachel, maybe.
And yeah, I think just to preempt, you know that my next obvious question will be, the compensation ought not to come from the public purse, it ought to come from UEFA.
Okay, so I mean, our starting position is that hosting Euro 2020 is an opportunity in addition to what these street trading businesses could expect in any other year. And the reality is that in order to host matches at Hampden, one of UEFA's requirements is that there can only be trading in event zones around Hampden and at any other event zones from UEFA approved traders. So I wouldn't say that it's a case that the street traders would require compensation, because, as I say, this opportunity is in addition to what they could usually expect in any other year. And the reality is that if we didn't put these measures in place, it is entirely possible that Scotland would not be able to host matches, and there wouldn't be opportunities for any of the businesses in Glasgow and in other areas of Scotland resulting from the tournament. Having said that, we did very carefully consider the existing rights of those traders, and that is why the bill does include that Glasgow City Council will offer alternative arrangements to street traders who are affected by the legislation. Street trading licences last for 3 years, so it's from licences that will be in force from this kind of summer. So there will be an opportunity for Glasgow to reflect the fact of the Euro 2028 events in those licences, so it's clear when street traders are applying that those dates, that it won't be possible to trade at those particular kind of dates and times around the championship. So that should be a lot clearer to street traders than it was for Euro 2020 when we brought forward the legislation much later, and I think it was more of a surprise for street traders at that point. So as I say, Glasgow City Council do need to make an offer of alternative arrangements to traders that are affected by the legislation. That might include offering an alternative location, and in which case Glasgow City Council have said that they would waive any temporary licence fee that was required for that. But there could also be discussions with traders about any other alternative arrangements that might be appropriate as a result of further engagement with them around about that.
Supplementary questions on that area. So I'm going to bring in Alexander and then George.
You've already indicated from Mr Kerr's questioning that the zones will be set up, and we understand that the situation around that. And it is Glasgow City Council who will have the power of enforcement, and it will be them who will then have the obligation to ensure that that enforcement is acted on. But you've already touched on what happens to existing traders who are specifically within that, and any exemptions that they'll be entitled to. So how are the exemptions going to be managed, and how are they going to be policed to ensure that if there is any enforcement that requires to be done by the City Council with reference to some of these traders, how that's going to be managed?
Okay, so in terms of who will be doing enforcement, yes, for the street trading and advertising offences, we would expect that Glasgow City Council would be the lead agency for that, although Police Scotland have all the same powers and could take enforcement action, and in some instances would be central to supporting enforcement officers in taking that action. Glasgow City Council also issue street trading licences, so have that existing relationship with street traders. In terms of exemptions from the trading offences, so again, reflecting on experience from Euro 2020 legislation and the Commonwealth Games, where we brought forward a lot of the detail of the exemptions in regulations further down the line. Those exemptions were fairly stable between the Commonwealth Games and Euro 2020. Some differences, but not a huge number. So on that basis, we've put a lot more of the detail about the exemptions into the face of the legislation. And let me just make sure that I get the right schedule for the trading. So yeah, so more of the detail around about the exemptions for the trading offence is now set out in Schedule 2. And again, the intention there is to give businesses more advanced, I suppose, understanding of what the exemptions are. So that's the kind of first point, but also understand that legislation is not particularly accessible and easy to understand for businesses, especially businesses, smaller businesses, we heard, really don't have particularly a lot of time to kind of understand the detail of the legislation. So I think that's why it's really important that there are also measures in the bill for Glasgow City Council to publish guidance on the measures in a format that's understandable for businesses, and Glasgow City Council have indicated that they will make that available in different formats, including accessible formats for those that are looking to understand how the measures affect them.
Thank you.
Mr Adam and Mr Bibby, is it on the street trading aspect?
It was actually the ticket thing.
Ticketing, okay. Miss
that most of the UEFA funding will go back into football, which is what it's all about. Because as someone who's involved in the fan ownership of St Mirren FC, I understand that most of their budget, the major budget line, comes from merchandise, and any unofficial merchandise isn't of the same quality, but also it takes away from football itself. So you can understand when a big tournament comes to town that they'll be wanting to go down that route as well. But that's not to say I haven't bought the odd flag from the Hearts, Scarves and Flag men, because it's mainly them we're talking about. It's not the burger sellers, it's the guys that are selling hats, scarves and flags and macaroon bars.
The food traders
I don't know what macaroon bars
well.
have got to do with it right enough, but there's always macaroon bars there
Food
as well.
trucks as well, yeah.
But the main ones that are really the issue are the hats, scarves and flags guys, because it's unofficial merchandise and they're getting moved on. And the important thing is that this is going back into football, and that's what this is all about, generating the funds for the football itself.
So I'm glad that you picked up the point about reinvestment. Yes, I did mention that earlier, but to be clear that UEFA does channel 97.5% of its revenue back into football, and that includes wider social and environmental projects. So yeah, that is a really important aspect. In terms of what the measures capture, so it is UEFA authorised partners that will be able to trade in the zone. So it will affect the kind of sellers that you are referring to in terms of hat scarves, those side of things, but it will affect the food vans as well. They would be within the event zone. And I suppose they might be one of the ones where it's more a location that they require, because a lot of the hat and scarf traders are more kind of mobile, as I understand it, in terms of how they operate. So we'd move around generally anyway.
We tend to only see them at St Mirren Park when we're near winning something, you know, so
Yes.
It's never really an issue for us. But it can be, actually, in a very, very serious point, it takes away from those that are actually involved in football as well. So we've got to kind of be concise of that as well. And I see there's always a place for these individuals, but I really think the idea of Glasgow City Council finding a spot for them, there'll always be a place for them. And I can guarantee you, as you walk up to Hampden at one point from various parts of Glasgow, you'll hear the call Hearts, Scarves and Flags. Because I will hear it when I'm going. But at the end of the day, I think it's about really getting to the crux of the money that's going back into football, and that's the whole point. That's what we're here for.
Thank you. I'll bring in Mr Bibby again. I've got another few members to come in. If we've got time, I'll come back to you, Mr Kerr.
Thanks, Convener. Good morning to the panel. You mentioned earlier it was difficult to gain significant amounts of impact data in relation to Euro 2020, obviously because COVID restrictions was limiting the number of people that could attend the matches. We've got, just in terms of understanding the context and the potential risks of Euro 2028, Hampden Park has a capacity of 52,000. We obviously hope and anticipate that will be full. What indication has UEFA given in relation to the amount of tickets they will sell at particular points in terms of general sale versus hospitality versus individual federations and the timescales for that? Because obviously understanding the context and the risks in relation to that, because people across Europe could potentially buy tickets. Also, have they given an indication on what the range of ticket prices will be from the lowest price to the highest prices? Because that's important for the context as well.
Yeah, so I'll maybe come to Rachel in a second if she's got anything to add. So again, because we're earlier bringing forward this legislation, there's more uncertainty around some of the factors that you're identifying. So we haven't had confirmation of match split yet from UEFA across the various different stadia. So that would be the kind of first step in terms of what you're identifying. UEFA will also be working on a ticketing strategy which will cover a number of the points that you've kind of picked up around about pricing and availability for different nations. What I would say is that for Euro 2024, tickets were available from €30 and there were 1 million tickets that were available for €60 or less, and that's from around about kind of 2.6 million tickets overall. Rachel, I don't know if there's anything more general you would want to add.
I think, as Lucy said, UEFA is still very early in their ticketing strategy. We will engage with partners to ensure that those issues around price accessibility are kind of front and centre within that. They do want this tournament to be a tournament for the fans. We are expecting that the tickets will be priced accordingly to allow that to happen. But clearly there will be a hospitality element to it in there as well. So we're probably a good 12 months or so away from a kind of locked down ticketing strategy, I would say, but it is very much in UEFA's gift to determine the timetable for that.
Yeah, I think that's clearly important because, you know, part of the reason for bringing these major sporting events is so that fans can access it at affordable prices, and we want to welcome as many fans from across Europe, but we also want to make sure if Scotland are playing that we've got plenty of Scotland fans in there supporting the national team. In terms of the timing of it, you mentioned summer 2026 being the expectations for UEFA in terms of passing the legislation in the Scottish Parliament elections in 2026. I just wondered though, given the Commonwealth Games is going to be in the summer of 2026, whether consideration had been given to perhaps wait until just after the summer recess in 2026 to see if there was any lessons that could be learned from issues arising from the Commonwealth Games in 2026.
So the timing of ticketing going out is UEFA's decision within that. So we will obviously get evidence from the Commonwealth Games. There are no similar restrictions for the Commonwealth Games on this occasion because of the circumstances in which it came to Scotland. We have no kind of driver from the Commonwealth Games Federation to put in place similar restrictions around it. But as with all of these events, we are always kind of looking at the event environment as well around it, and we will see what's going on with those tickets. So we will continue to kind of roll that forward, and we will share those lessons with UEFA.
Okay, thank you.
Did you have any other area for a question? Thanks, Mr. Bibby. Patrick?
Thank you. Good morning to our witnesses. I wanted to ask about the enforcement provisions. And I'll just say up front, I apologise, I've not yet had time to compare the bill to the 2020 bill, both as introduced and as passed. And it's the changes that were made to the 2020 bill during its passage through Parliament that I'm interested in. In particular, there were arguments about the need to protect people against personal searches and searches of their electronic devices. The argument being that police already had those powers, and that when police exercise those powers, they have set procedures and safeguards to protect people when they suspect that a crime is being committed, and the expansion of those powers to council officers for the purposes of trading and advertising offences could have risked the unnecessary violation of privacy rights. So can I ask, has the government modelled the new bill on the 2020 bill as it was introduced or as it was passed? Have the changes that were discussed and agreed by Parliament at that point been incorporated into the new bill?
So I think when we were looking at the enforcement provisions, we have looked at the discussion that happened, the discussion with Parliament last time, and the amendments that were made as a result. We've also considered how enforcement worked in practice on the ground for Euro 2020, albeit that was limited because of COVID. And we've also kind of thought, could we take a fresh approach to drafting? Because I think quite a lot of the feedback last time was it was quite difficult to follow the enforcement provisions as well. So I think, having looked at that, we didn't think it was possible to take a completely kind of new approach to drafting that would make things clearer. I suppose what we have done is we've tried to label the different sections a little bit more clearly, hopefully, so that it's easier to kind of follow as you're going through. In terms of some of the safeguards that you've picked up, so section 22, power to enter and search. So that covers when permission is given by an occupier or another person with the authority to do so. An enforcement officer may, without warrant, enter any place and may search any place. So that's a vehicle, vessel, container or other thing at that place. Subsection 2 of section 22 does make clear that that does not authorise an enforcement officer to search an individual or to access data stored electronically, which I think is one of the points that you were picking up that was kind of feedback from last time. So yes, I think that would be an example of something that we've taken on board.
So it wouldn't include the power to access the data on devices of that kind. Would it include the power to seize or to destroy those devices?
Yeah, which is about power. So power to seize if it was commissioning a championship offence, yes, I think so, but there are protections in place around about destroying. So I think potentially could be seized. Wouldn't be possible to access data stored electronically, but I think there are protections in the bill around about the powers to destroy, that would be a last resort and not something that would be done lightly. Ninian, would there be anything around about these powers you would want to add?
Yeah, yes, yeah. As you said, the safeguards obviously applies set out in sections 20, section 21, and it's very much I think it's envisaged that it's the power to destroy would be very much a last resort, as Lucy has said. Yes.
And the power to destroy, even in that last resort, would be exercised by council officers or by police? Or both?
Enforcement, both have powers to do so, yes.
I think that's perhaps something that we'll need to discuss in detail as we get into the evidence on the bill. I just wanted finally to ask about the. I mean, Mr. Kerr was talking about some of the purposes of the protection of monopoly rights that UEFA and others who organise similar events insist on, and they would make the case that that's necessary in order to make the event commercially viable. Mr. Kerr, perhaps understandably, was talking about the impact on other businesses that might want to compete for that custom. There's also a concern about the impact on civil liberties in terms of protest. There have been a number of instances, not just in this country but around the world, where similar legislation has been used not against commercial operators trying to rip off a brand, but against messages or protest or expressions which criticise some of these multi-billion-dollar brands around the world for their ethical behaviour. Where have you drawn the line, or where has the government sought to draw the line in terms of the impact on protecting those brands that UEFA will be concerned about and their partner businesses will be concerned about, and the need to protect civil liberties, either at the level of organised peaceful protest or, for example, somebody wearing a T-shirt that satirises a brand?
Yeah. So, again, I think it's hopefully it's useful for the committee in that we have included more of the details of exemptions from the advertising offence in the schedule. So it's Schedule 3 on this occasion. So that includes an exemption for demonstrations, which includes where the demonstration is to support for or opposition to the views or actions of any person, to publicise a belief, cause or campaign, or to mark or commemorate an event. There are also exemptions in there around about kind of wearing of particular T-shirts and things, I suppose, as long as the person is not knowingly trying to participate in ambush marketing. So as long as that's not their intent, is I guess a kind of coordinated ambush marketing. So hopefully that's useful for the committee. Those are replicated from Euro 2020, but as I say, there's more detail now in the bill itself about those exemptions. So hopefully that's useful. Ninian, I don't know if there would be anything else you would want to add on that in terms of ECHR considerations.
No.
Not on this occasion, okay.
That's helpful. Thank you very much.
Okay, Mr Brown.
Just a couple of quick questions. One, on the consultation which you held last year, a fairly limited number of responses. Is there anything you can point to which changed in your plans as a result of that consultation, rather than change because of your experience?
So I think there was a relatively limited number of responses to that consultation, so 26 responses. The team that was leading on the development of the bill did undertake a number of different routes of engagement. So they also held a couple of in-person drop-in sessions in Glasgow. They also held a couple of virtual webinars. As we've already covered, they attended a Mount Florida Community Council meeting. They did extend that invite to engage to other community councils. We had a letter drop for a half a mile radius around about George Square, Hampden and Glasgow Green to try and raise awareness of businesses and people living in those areas of the legislation. And Glasgow City Council contacted all current street traders to make sure that they were aware, and a couple of the team attended a match at Hampden to try again to raise awareness in street traders that were there. So I think while there were, I suppose, a reasonably small number of responses, I think the team did really try hard to raise awareness of the measures that we're talking about. I suppose in terms of feedback that we've taken on board, Federation of Small Businesses, as I've already mentioned, noted that small businesses in particular might be time poor and find it difficult to engage with the detail of the legislation, and therefore really important that there's clear guidance available. So that was already a measure in the bill, but we're doing that again. There was also feedback from the kind of equalities engagement that providing guidance in different formats and ensuring that there was an interpreter available if necessary around about any enforcement action where English wasn't a first language for someone being engaged with would be important, and that's something that we've engaged with Glasgow City Council, and that they've said that they are happy to kind of put in place around about that. So I suppose those are the types of things that we've taken on board. There was also wider feedback, including from Mount Florida Community Council, but also I think through some of the other routes of engagement about other issues, more general kind of issues around about the event, so things like road closures, availability of toilets around about Hampden, that type of thing. So while that's not directly related to the legislation, we have shared that feedback with partners again, so that they're able to kind of consider and take that on board in terms of wider event delivery.
Okay, thanks very much. Just going back to the point that Stephen Kerr raised, just to see if I'm getting this right, that the legislation as proposed would not be able to prevent folk from out with Scotland from indulging in ticket touting for matches that are held in Scotland.
Yes, so it's only tickets that are touted for people who are based in Scotland, where Police Scotland will be able to take enforcement action this time. Yep.
And the reason I think you gave for that was it was deemed to be, in discussions with others, disproportionate to allow that to be the case. What about the reverse? Are you expecting legislation anywhere else that's hosting a match to be able to reach into Scotland for matches held in England, say for example, to prevent touting in Scotland for matches held in, or is it the same, everyone's just looking after their own patch and the internet will be the internet?
So as I say, we are engaging, we're working closely with the other host nations, including through our legislation working group. I'm not able to talk about what other governments might bring forward, but certainly in terms of our engagement, I think we have been clear that we will subject to parliamentary approval, expect to have a ticket touting offence in place, and it would make sense that others are not able to reach into Scotland. I think we want to have one clear offence that applies in Scotland so that people in Scotland understand how the ticket touting offence works. I think it would be difficult if another jurisdiction was reaching into Scotland extraterritorially, so that you had different offences applying. So that's certainly the position that we've adopted in engaging with other host governments. But as I say, I'm not able to comment on what they might bring forward. That would be for them to comment on.
I understand that point. I think it will be important for the Parliament, though, to be able to have that information before it takes a decision in due course.
Would it be helpful if we followed up with partner governments on what they are able to say about what they might be planning at this stage?
I think it would be helpful, yeah. Another couple of quick questions. Just to say on the point that Patrick Harvey raised in terms of protests and so on, it does seem a little bit, you can tell by the tenor of the questioning, that the kind of very heavy presence that UEFA insist on, whether it's crushing indigenous entrepreneurs, which is one way of looking at it, or the monopoly that they have on merchandise, and I understand the point George Adams made, it does seem very heavy-handed sometimes, I think, and it seems to be the price that you have to pay. Well, this time is it not the case that the UK was willing to step forward when others weren't, so perhaps the bargaining position, I don't know if that's a question more for Rachel McKechnie or not, if we had more.
So that was the Commonwealth Games, Mr Brown, rather than this. So this was a
bid process. We were talking about that before we came in. What led to, remind me, the UK getting this championship?
So this was a contested bid. Turkey were the other nation that were in the run-in at this stage. So it was a UK and Ireland bid that was successful at that stage. So
a standard, only 2 contestants seems unusual. There was talk that Germany might have been involved but pulled out of it, is that right?
So Germany had 2024, so they had the kind of precursor to this.
And my last point was, well, just to say on the point about protests and so on, I think that Police Scotland did an absolutely superb job for COP26, I think it was. And they pre-engaged with different groups that were going to a huge engagement. It's a different scale. It's a much bigger scale for COP26 for all sorts of reasons. But I would hope that would be the similar approach, although the senior personnel's all changed.
Yeah.
And the last point was, and again, it's probably for Rachel McKechnie, when it came down to the bid, was any consideration given to whether Scotland could have 2 venues and whether Murrayfield could be considered? I just think the potential number of people that want to visit Scotland and Edinburgh, and also the bigger capacity at Murrayfield might have been attractive, although was that just a factor of a more or less equal distribution or equitable distribution between the different home nations? And also was part of the decision because of, is there some kind of criteria about the level of corporate tickets, places that are available, which Murrayfield didn't qualify? I don't know if you know.
So there were a range of options that we looked at when we were putting forward the bid. What I would say is that stadium selection is wholly a matter for UEFA as well. So when we looked at those options, we were kind of very clearly thinking about geography, capacity, where UEFA would like to go, and obviously because it is a 5 nations bid at that stage as well, there was how could matches be split through as well. So we got to the point where we felt that Murrayfield was probably not the best approach for it, and that Hampden would actually offer the best value for money for Scotland for this particular event.
That was the reasons why you would end up at that conclusion I was quite interested in.
So UEFA have got very stringent requirements within there. There's certainly a look at stadium capacity, stadium, even the shape of stadiums in particular as well. So obviously Murrayfield is a rugby stadium. It's better constituted for rugby matches as well, whereas Hampden is a purpose-built football stadium. Connectivity for Glasgow, obviously kind of Glasgow's very strong prowess for delivering huge international sporting events as well. So yeah, a range of kind of different factors that came through there.
The very last point is, well, just to say Murrayfield has hosted football matches before, but not that it's likely to trouble Scotland, but as for the later stages of the competition, what is the criteria as to which stadiums will be chosen? Is it depending on who's still in, or?
Some conditions from UEFA around capacity, and they will also be looking at things like international connectivity within there as well. Yeah.
Would that then mean that Hampden, having the capacity, as has been mentioned, of around 52,000, it would be unlikely to be a venue chosen for a later stage match? Or?
We are, yes.
Yeah. Okay. Thanks.
Mr Kerr, did you want to come back in?
2 points. I just want to clarify, because I agree with Keith Brown, some of this feels very heavy-handed to me. Just perhaps how you see things, but it just feels that way. I know what George Adam has maybe taken a different view. For example, in section 7, clause 7, charities can't have a shaking tin outside a venue for a good cause. Why is that felt to be a threat to the commercial might of UEFA?
I'll come to the charity point in a second. I suppose the measures in the bill, street trading and advertising, apply to particular areas in Glasgow for a short period of time around about the championship. I think compared to the overall opportunity that the event presents economically for Glasgow and for Scotland more generally, we do consider that they are proportionate, and as I've already covered, they are a requirement in order for Scotland to host. So I suppose that's the decision that we make around about hosting. In terms of charity collections, again, if we look at Schedule 3, that includes an exemption for charity collections under, is it Schedule 2? Sorry, Ninian.
2.1.2.
Thank you.
Schedule 2, paragraph 1Q.
1.
Yeah, so there's an exemption for charitable collections where they have the normal authorisation from Glasgow City Council.
So it's activity under section 119 of the Civic Government Scotland Act 1982 charitable collections. So that's the existing process. So that allows charity collections to be managed in the way that they would be for a normal match day. So that exemption's in there. So again, hopefully that's helpful to see that on the face. No, it's a lot of detail, as I say. I think that's why it's particularly important that the guidance is provided by Glasgow City Council when we've got a final bill to make sure that these things are apparent.
Okay, that's useful to know. I note that busking is also...
yes, busking is in that list above N.
So my last point, because there are so many issues, it's good that you're here and it's good that you're being so upfront with your answers, but the issues of enforcement that Patrick Harvey mentioned, if I can go to what it says in section 24 of the bill, there's a bit in there that I really couldn't understand, and it might be because I'm not a lawyer, but it might be because the whole idea of people forcibly entering a premise without a warrant feels really foreign to me, and that's what it says in 24(2)(b)(1). The constable reasonably believes, now this is in relation to the merchandise issue, I think, that George Adam referenced, but if a constable reasonably believes that there is a real and substantial risk that delay in seeking a warrant would defeat or prejudice the purpose of taking action. I mean, in the context of policing, if it's perceived by an officer that there's a risk to life, then they may enter any premises. That's understood. This seems, again, unless I'm not understanding the language, what is the real and substantial risk of someone having a bunch of scarves, hats, and don't quite get that? What's the other one? Flags. Flags, yeah, flags. Metal badges, they're very popular as well. What is the real and substantial risk? And it just seems really Strong-handed. I think that is strong-handed.
So I think the starting point for the use of reasonable force, so the bill gives enforcement officers and of course police constables the power to enter and search with permission or with a warrant.
Yes.
And then the warrant does expire when it's no longer necessary.
Yes.
And then the next bit that you're picking up is if there is a real and substantial risk that delaying in order to seek a warrant would defeat or prejudice the purpose of taking action.
Yes.
An enforcement officer can enter and search with neither permission nor warrant. And what you're picking up quite rightly is that there's a higher bar for that. So for the first part around about enforcement officers' power to enter and search with permission or warrant from the sheriff, there's not a need, as I understand it, for a police constable to be present then. However, where there is going to be where that is going to be used without a warrant or permission, then that decision can only be taken by the police officer. So that decision can't be taken by an enforcement officer. No. So that is a higher bar in terms of police decision making.
This is a really high. I mean, we are allowing police officers to do things they would not normally do, other than the case of the risk of a real and substantial risk of life.
So, okay, so I would need to double check, but I think these are the powers from the previous legislation, and I think I would also want to double check just how they compare to existing police powers, if that's okay, and come back to you.
Of course, that's the whole point of this. I appreciate that, and of course, I think the significant thing, as I understand it from the 2020 legislation, is there was not one conviction.
Not from 2020. There was
no,
from.
Of course, it was a slightly different sort of an event, but anyway, yes. So I think that would be very useful, because that no doubt will come up again as we continue to scrutinise the bill.
Okay. Does that conclude questions from the committee? Can I thank you all for your attendance at committee this morning? That was very helpful. I obviously look forward to the issues you have agreed to follow up on, but we may well take the opportunity to write for more information as well. Okay, thank you very much. And on that note, we go into private session.